What to expect in your first meeting with a personal injury attorney after your accident. Hi, I'm Matthew Konecky, and in today's video, we are going to talk about what happens when you meet with a personal injury attorney, and so you aren't unprepared, because this could cost you time and money. So in today's video, we're going to talk about documents to bring, the questions you'll be asked, how attorneys evaluate cases, red flags to watch for, the fee structure, what happens after you sign up. But stick around to the end because we're going to give you 3 insider tips to maximize your consult. Okay, let's talk about the documents to bring. The first one's easy. If you're given a police report or a driver's exchange information, you're going to want to bring that. If you've downloaded a crash report, bring that, because that's going to help the attorney look and see if there's any issues on liability. It's going to also give potential other witnesses that may have seen the accident, and that can help jumpstart the investigation into the case. Now, obviously, the next thing is any kind of medical records. It's a personal injury case, so you have to be injured to maintain a personal injury case. And so by the time you're seeing an attorney, you should have already gone to a doctor or an emergency room. Maybe it's a chiropractor. Whatever it is, you're going to want to bring any kind of records from there. And if you've gone to a chiropractor or your primary care physician, it may be beneficial just to bring a card if you don't have any records, because that way the legal assistant or the attorney can reach directly out to those providers and make a request for any records that they have generated. The next thing you're going to want to do is bring photos of the scene or your vehicle. If you've already had your vehicle assessed by an insurance company and they've gotten any estimates, you're going to want to bring that. So the photos of the scene can help depict of what it looked like at the time of the accident. The photos of the vehicle is very helpful. If it's a rear end accident, liability is going to be pretty clear. However, if it's, for instance, a T-bone accident and the other party is saying that they had a green light and you think you had a green light, there could be something from the scene, the photos from the scene, that can help detect whether or not someone's lying or not. So it's important to have that. We actually did a video about how to secure this information. We'll give you a link to it below. So it's important to bring those photos ahead of time. It's also important to bring your insurance information. And now you may be thinking, why do I have to provide my insurance if somebody else is at fault? Well, in Florida, Florida is a no-fault state, and your own personal injury protection benefits are primary for your medical care up to the first $10,000. So having your insurance information is helpful to get what we call a PIP payout log, but it's also important to help understand the coverages you may have, because beyond your PIP, you may have something called which is uninsured or underinsured motorist coverage. And if you maximize the other person's insurance, bodily injury insurance, or if they don't have any insurance whatsoever, your comes into play. So having that ahead of time, a lawyer doesn't have to wait for an insurance disclosure to know how much insurance you have. Now, if you've lost wages from this accident and you haven't been able to go to work, if you have any documentation of that, that's also very important to have. Bringing a check stub to show how much money you make a week. For instance, if you are out a week of work and your salary, you make $1,000 a week, that kind of information for an attorney to have up front is very important. It can also help establish long-term what your damages are if you can't return to work. I also suggest that you bring to the first appointment any messages, emails, or social media posts that you happen to see regarding your accident. And what I mean by that, if you, through the driver's exchange information, you learn that who the other party is, and if you happen to see that they're posting about, oh, I screwed up today, I hit, this other vehicle, well, having that ahead of time can make the attorney's life a lot easier, because that person is likely going to be told to take down their information. Likewise, you shouldn't be posting anything on social media about your accident, because anything you say can and will be used against you. But if you get messages from even the person involved, apologizing or anything like that, save those. It may come in handy later. Likewise, If there's any witnesses that may have contacted you as a result or messages, you're going to want to save that information and give it to the attorney at the first visit, because if there is an issue of liability, it's a lot easier to call the witnesses closer to the time of the accident when they have a fresh memory. So having that information and giving it to the attorney so that they can secure a statement right away is crucial. And then lastly, you're going to want to bring a timeline of the events. Now, if you're seeking a personal injury attorney months down the line and you've already gotten treatment for your injuries, you're going to want to kind of relay everything that happened thus far so that the attorney is aware of which doctors to see, which hospitals that they need to request records from. You may also in that timeline put, well, you missed 3 days of work because you just weren't feeling good enough to go back. Your back or your neck was hurting you. That kind of stuff is very important. It kind of sets the tone for the case of, what the attorney can expect moving forward. So those are the documents that bringing to the attorney ahead of time is going to be very, very helpful so that we can get a start on the case. Likewise, if you can give this information prior to the actual meeting, that could even help the attorney get up to speed quicker. It can also make the visit to the attorney much more useful. Now let's talk about the 5 key questions I know you're going to be asked. Number 1, of course, what happened? So you're going to need to be able to articulate what happened in the accident. And God forbid if you were knocked unconscious and you don't know, well, that's the appropriate answer. But the important thing is that you can give a very clear, concise statement as to what happened and be prepared to answer follow-up questions on that. This is important for the attorney to flush out any kind of issues of liability, but it also gives you your first opportunity to show the attorney that how well you remember the things that have happened and how you might appear if this goes to trial, how you might appear in front of a jury. So number 2, what treatment have you done? So as we said before, personal injury cases are valued at what your injuries are. And the only person that can identify your injuries other than you complaining about pain is a doctor or medical professional. So you need to be able to list where you went to a hospital, where you went to follow-up treatment, whether it's physical therapy or chiropractic. If you saw an orthopedist, did you go for an MRI? Have all of this information ready and accessible to that attorney so that they can ask you questions about it. Now, this is not only for the information from the accident, but if you've been in prior accidents or maybe had a sports injury, you're going to be asked about that too. Because if you had a prior injury, doesn't mean that you don't have a case, but it means that this new accident may have affected it, and what effect it has on that prior injury, it's called an aggravation. That can be helpful in the case. So be able to prepare to talk about your prior medical history as well as the treatment you've already done. The other thing that they're going to ask you is, how has this affected your life? Now, if you're early on in treatment, maybe you don't have an answer to that. But if you're talking to an attorney for the first time after you sought lots of medical treatment and you just aren't getting anywhere and that's why you're pursuing a claim, you need to be able to document how this has affected your life. And I even tell clients at the first meeting is, you may not know it now, but as treatment goes on for 2 or 3 months, you need to note things that you can and can't do. For instance, if you were an avid runner prior to the accident and now you don't run anymore because it hurts too much, you need to note that. If you have to hire somebody to help clean your house because you can no longer bend over to scrub the floors or fold laundry or something like that, that is how it's affected your life. With that, if you have to hire somebody else to do something, you need to keep the document of who you hired and how much you paid them, because those are damages that are used to compute the value of your case. Anything that has to do with how it's affected your life is important to give to the attorney at that first meeting. Now, the attorney's going to ask you if you've spoken to any of the insurance companies involved here, because not only have you had your insurance company that you're making a claim with, you're going to have the other party's insurance information who may reach out to you. And why this is important is the attorney needs to know who's reached out and what have you told them. Because if your story is inconsistent and there's a recording of your statement to the other insurance company, for instance, they call you to check on you're doing, and you say, oh, I'm okay, I'm fine, I'm not injured. And then 3 days later you go, well, actually my neck kind of hurts. And then you get it checked out and you do have an injury. Be sure to know that insurance company is going to take that recorded statement of you and use it against you in the future. There's ways that attorneys can handle this, but you need to be prepared to let the attorney know, as I did speak to that insurance company, and I kind of told them I was doing okay. Doesn't mean that on that day you weren't doing okay, but the next day you weren't injured. It just gives the attorney an understanding of what he may be up against or she may be up against in the future. And then the last key question expect to be asked are, what are your goals of this case? For some people, the goal is just to be made whole. You want to get feeling better again, and you want to feel good and make sure your car's taken care of and the time you lost from work is made up. That's a goal. Some people is like, I want it, a gazillion dollars. That's a goal. It's important for the attorney to know that, to make sure that they're the right fit to help you meet that goal. Because not every attorney is going to say that your case is worth a gazillion dollars. And it's important that you work with the attorney that wants to help you achieve your goal, whether it's getting to be made whole or, reach for the stars kind of settlement, because not every case is like that. Expect to answer what are your goals for the case. Let's talk about how attorneys evaluate cases. So there's really kind of a few things that they want to look at. First, obviously, is liability. Well, what's liability? Liability is who's at fault. Now, Florida is a comparative, or now modified comparative negligence state. And what that means is that even if you're partially at fault, you can still recover. So as long as you are 50% not at fault, you can recover. What does that mean? So for instance, if you were in an accident, but part of the accident is your fault, and a jury determines that you are 25% at fault, that means you're 75% not at fault. It means that whatever the jury awards for the damages, you can recover 75% of that. I'm not going to go into a big explanation of why someone could be 25% at fault or 30% at fault or 50% at fault. I'm just going to say that you can, even if you're deemed partially at fault, you can still recover. That is the first evaluation, and what attorney does is look at the police report, the photos, everything that we've previously talked about earlier, witness statements, to kind of determine liability. Is there strong liability? A rear end accident is really easy to establish liability. If you are slowing down and you get rear-ended from behind because they didn't pay any attention, there's good liability there. So that's the first thing that we look at. The second thing that we look at are the damages. And that's not only just the damages to the car, it's damages in the case. And damages can be economic and non-economic. So economic damages are the medical bills that you incur as a result of the accident, the medical bills that you will incur in the future for treatment. If you are diagnosed with a herniated disc and the doctor says you're in the future, you will need a surgery. Those are things that you can anticipate what they'll be in the future. Those are things that are economic damages. And of course, non-economic damages are things like pain and suffering. And, that's based on how you feel on a day-to-day basis and what you might feel in the future. And really that's an award given by the jury. But on a significant impact case, or a case where, there's been a lot of medical treatment, an insurance company might look at that and say, yeah, there's going to be a lot of non-economic damages here. One of the most important things, and that I think most people don't understand, is for most personal injury cases, it really comes down to insurance coverage. You could be completely not at fault. You could get rear-ended from behind. You could go to the hospital. You could have multiple surgeries. You could have broken your leg. But realistically, if the person who hit you doesn't have insurance and you don't have uninsured motorist coverage, personal injury attorney may not take your case. And I know it's shocking to hear that, but if there's no incentive to get a settlement out of someone who couldn't afford to have insurance in the first place, there's no incentive for them to maintain this case and spend money. And we're going to talk about that in an upcoming section, the fee structure. There's no incentive to sue somebody who can't afford to pay a judgment. So having the right type of insurance, and we've done lots of videos on that, and you can look at our website and learn more about that. The amount of insurance that you have and the other party have is imperative in doing a whole case evaluation. And then lastly, we're going to look at statute of limitations. None of this matters is if you're going to your first consultation on a personal injury case and you've gone after the statute of limitations, because statute of limitations on most personal injury cases in Florida is 2 years now. It used to be 4 a few years ago. They changed it to 2, meaning that if you have waited 2 years from the time of your accident to consult an attorney, by law, you will not prevail. You cannot file the claim. The claim will be dismissed because you violated the statute of limitations. So that is a key component in there. Timeliness is something that any attorney is going to evaluate in your case and talk to you about at that first meeting. Understand that at your first case meeting, you're going to be talking about liability, you're going to be talking about damage, and you're going to talk about insurance coverage, but it won't matter unless you've done it in a timely fashion. And there's one more aspect of the time. Your PIP benefits vest if you see a doctor within 14 days of the accident. If you're outside of that window, you may still be able to maintain a case, but you may not have all of the benefits you normally would have had you seen a doctor within that 14 days. Now, I want to talk to you about some red flags if you're going to meet an attorney and some of these things pop up. First, a guaranteed outcome. Florida Bar does not allow us to guarantee any type of outcome. So if an attorney says, you sign with me, I'm going to get you X amount of dollars on day one, that's a red flag. And it's a red flag because, like I told you, Florida Bar does not allow us to do that. But number two, if you are just injured in an accident and you haven't gone through all the medical treatment, you don't know what all your damages are, how is this attorney going to guarantee the amount of money to you? Now, obviously, if you were in a hospital and you were severely injured and you ended up then seeing that the other person only had a $10,000 bodily injury coverage and you have no it's more likely that you'll get the whole $10,000, but no one should guarantee that. Another red flag is someone pressuring you to sign right then and there. You should read every document that is given to you and take the time to take it home and then sign if you're comfortable. Or if you're comfortable signing there, that's not a problem. It's just that when anybody pressures you to sign, you shouldn't feel that type of pressure when seeking advice of counsel. No fee transparency. And what I mean by that, and we're going to talk about fees in a bit, every time you sign up with a lawyer, you should have a written contract, and that contract should spell out exactly what the percentage fee is and how it'll get paid. And we're going to talk about that in just a bit. But if you see something that says, yeah, lawyer X is going to represent me and I will pay them, that's not transparent. Another red flag is, are you actually meeting with an attorney, or are you meeting with a paralegal, or are you meeting with an investigator? Now, I'm not saying that you can't meet with those people and get your case signed up, but if you want to speak with an attorney to get their opinion on the case, you should be able to. After all, you're trusting your case and your life to a firm to help you. You may want to know who you're meeting with and why or why not you're meeting with the attorney handling your case. One last red flag to be aware of: if you've never contacted a lawyer's office and a lawyer's office contacted you, that's a red flag. As attorneys, we are not allowed to solicit business for personal injury cases. That means no lawyer should have access to your auto accident and call you up within days to say, hey, we want to help you. There are people called runners that work for sometimes chiropractor offices or medical offices, and sometimes even lawyers that say, hey, if you sign up, we'll give you $1,000 just to get started on the case. That's an illegal practice. And if someone has done that, that means not only are they breaking the law, they probably don't follow by the rules, and they're probably not a good attorney. So the biggest red flag is if you're consulting an attorney that has used a runner. Stay away. Now let's talk about fee structures. Generally speaking in Florida, the fee structure is this. If the case can be resolved prior to filing a lawsuit, meaning that the attorney hasn't filed within the courts, but is settled directly with the insurance company, the attorney's fee is 33 1/3%. But if a lawsuit is filed and the defense files an answer, it goes up to 40%. And that is also something that should be discussed by the lawyer prior to them filing the lawsuit. But that is what the fee agreement typically is. Let's just give an example. Let's say the case settles for $100,000. That means if it was prior to a lawsuit, the attorney's fees in this is $33,333.33. Understand that ahead of time. That could happen if your case is settled within a week or a case is settled in 4 years. That's what the fee is. While it may seem unfair because the attorney put his effort into it ahead of time without you giving them a standard attorney's retainer of several $1,000s, that's the price you pay for doing a contingency fee. Now, the benefits of that is you don't have to pay an attorney to start working on your case. And the attorney has the incentive to get you the most money because they're going to get themselves the most money. Things to consider, though, in that contract are the attorney may be outlining fees associated with the case, meaning medical records, investigative reports, maybe even an expert to determine liability. And all of those costs typically come out of the settlement as well, not within that 33 or 40% under the fee agreement. So these costs are separate and they come out of the bottom line. Another thing to consider too is if your medical treatment goes beyond your PIP and your health insurance, some of the doctors will hold balances, meaning that they won't charge you up front, but are expected to get paid back after your case settles. And that also can come out of your settlement. Or if the hospital files a lien in your case, for instance, you were in the hospital for a few days and you have a $100,000 bill, you weren't expected to pay for it when you left the hospital. So the hospital could actually put a lien on your case if they find out that this is a result of a personal injury action. An attorney has a duty to pay that out. And of course, it's going to be paid out of your settlement. So those are things that you have to discuss. And if you know you have a giant bill from the hospital, you may want to discuss that at that first meeting with your attorney. Now, let's talk about after your first meeting. What are the next steps? When you meet with your personal injury attorney for the first time, presumably you sign up. That attorney should give you a plan of action. Hey, what's going to happen next? And typically what that's going to be is that the case manager will be, sending records requests to anybody that you treated with. They're also going to make sure that they have all the information for the other party involved in this, and they're going to get that from the police report. They're also going to make sure that you are going to follow up with the treatment that you're already doing, and if you need additional treatment, maybe help guide you to where you need to find that. The plan of action for any personal injury case is to help you get better, to get back to a baseline so a doctor can say, hey, you're 100% better, to back to your baseline, or you are at maximum medical improvement and there's nothing more conservatively we can do, and as a result you have been permanently injured. And why that's important is that in order to get pain and suffering, you have to have suffered a permanent injury as a result of this case. So the plan of action should include who's doing what your responsibilities are, and that is to treat, and when you can expect to hear from the lawyer, or when the lawyer can expect to hear from you. Those are the plans of actions any lawyer should go through. Now, one of the crucial questions you should have is, and what I hear a lot of time is, what's my case worth? When can I expect a settlement? Those are the questions that you may have, and it may not be appropriate for an attorney to answer. Why? We don't know what your case is worth because we don't know all of your injuries. And like we discussed at the very beginning, the things that are important to have at this meeting is, what are the insurance policies of both you and the other party involved in here? Those are things that we don't know. So it may be something that you want to know, but it's not something that any attorney should be able to give you on the first day, because we don't have a crystal ball, and if we don't have all the information, we can't give you an accurate assessment. Now, what your case is worth, That's something that I've written about, and it's actually a book that you can download directly from our website, and we'll put a link below. Okay, so here are 3 insider tips. When you go to your personal injury attorney's first visit, bring a friend or a trusted confidant, maybe it's a family member, with you, because you might get caught up in the moment of wanting to tell about your case, that if you don't take in what some of the questions the attorneys ask or what you're supposed to do, a good friend will be there to help and assist to make sure you're on the right track. Number 2, write your questions down ahead of time, because although I think we've detailed a lot of the information that's going to be talked about today, this conversation here may generate questions that you want to ask, but if you don't write it down or you don't ask it in the email ahead of time, you might forget. And then you'll be like, I forgot, and then want to call. So have it ready ahead of time. And number 3, ask about their experiences with cases like yours, whether if they believe that it might need to go to trial, and if they have gone to trial, get a little bit more about their experience on cases like yours. Now, again, as we discussed, they don't have a crystal ball. If they don't have all the information about what the insurances are, what your injuries are, what your bills are, they're not going to be able to give you all of the information, but you might be able to get a little bit more from them to make you feel more comfortable. So I hope through this video we've answered a lot of the questions that you have, or you feel more prepared to go to your first attorney visit. So what I want you to do is download my guide, What the Heck is My Case Worth? It's available here. You can click one of the links below. Also, we have another video, Why Waiting Around to File a Claim Could Cost You Money, is also available right here. And lastly, if you are in South Florida and you need help on a personal injury case, you can contact us today.